So welcome to webinar 2 in our series of webinars on municipal courts. I am Justin Weinstein-Tull. I'm a law professor at Arizona State University, and I am part of the Municipal Court Steering Committee working with the Center for Justice Innovation to bring you this webinar series on municipal courts. I study local and municipal courts myself, and I'm really excited to be part of this series. Um, the webinars each explore different facets of municipal courts, in part because we think that municipal courts are a really important thing to talk about, and a set of institutions that don't get talked about enough. If you care about the justice system, then you should care about the way that people experience the justice system, and people overwhelmingly experience it through municipal courts, and not through the federal courts that we often spend a lot of time thinking about and talking about. And hopefully you all caught last month's webinar, sort of providing an introduction to municipal courts led by Professor Natapov. And if you didn't, I recommend it to you. It was fantastic. And if it's not available now, it will be available to watch at some point soon. So this webinar today is on the role that municipal courts play in our democracy and in our local governance. It is about putting municipal courts into context with individuals and other institutions. We know that these courts play important roles in people's lives, but they also play important roles in the entire communities that they serve, in the local governments where they reside, and even in the sort of entire state and federal justice system that they are a part of. So in this webinar, we're going to start with a sort of brief reintroduction to municipal courts. In case you weren't able to catch the previous webinar, just a description of what they do, who they serve, just as some basics. And then we'll move slightly outward and talk about the role of municipal courts in the communities that they serve. Some municipal judges are elected, some are appointed, but in all of these courts, judges, clerks, staff come from the communities that appear before these courts and can tailor their justice to those communities. From there, we'll move slightly outward again and talk about the relationship between municipal courts and their municipalities or their local governments where they exist. We know that municipal courts are the part of the justice system that people most likely come into contact with. But municipal courts are also can be the piece of local government that people are most likely to come into contact with, which makes them an important part of local governance as well. And finally, we'll sort of keep expanding outward and talk about the relationship between municipal courts and the broader justice system and the state and federal court systems. So before we get there, I just want to introduce our presenters today. We have three fantastic presenters for you all today. Our first is Jake Falaschini, who works at the Alliance for Justice as their program director for justice. Jake is a lawyer and a policy advocate with expertise in federal, state, and local justice systems. He helped direct policy, research, and advocacy on the state and federal courts. And Jake is going to talk about what municipal courts do. Our second presenter will be Judge Sparks, who is the presiding municipal court judge in the city of Birmingham, Alabama, and has decades of experience with municipal courts and how they operate within their communities. And Judge Sparks will be talking about the role of municipal courts within their communities. Our third presenter will be Judge Howson, who is a district and municipal court judge in Skagit County in Washington State. Judge Howson has a lot of experience working with her local government to innovate new programs within the court system, especially drug treatment programs. And Judge Howson will talk about the relationship between municipal courts and their local governments. She may touch on things like separation of powers in local government, where the courts fit in, and maybe funding from local government and how it relates to these municipal courts. And finally, I will finish things off by talking about the relationship between municipal courts and their states and the broader justice system. So feel free to write questions in the question box or the Q&A box. If there are questions, we'll try to respond to them at the end of the webinar. Hopefully there will be a few minutes left at the end for some Q&A or for some discussion between the panelists. I may follow up with some questions of my own. And with that, I would like to turn this over to Jake.
Thank you so much for that introduction, Justin. It's an honor and a privilege to be here with you all and to present with this esteemed panel. My role this morning is to provide some definitions and frames for exactly what it is that we're talking about here, municipal courts, possibly the most overlooked, under-researched, and yet deeply impactful body of courts in the United States of America. While these courts are under-researched, my understanding of these courts on a broad scale would not be possible without the invaluable work of scholars like Professor Weinstein-Tull and Professor Nadapoff at Harvard Law School, who presented on our first panel on this topic. I've been studying the state and federal courts for nearly 2 decades now and have helped dozens of potential judges seek positions on local and municipal courts. So my experience is deep in particular jurisdictions, but has breadth in large part due to my reading of the few scholars who really do focus on these niche courts. So what exactly are municipal courts? What are we talking about? Municipal courts are trial courts of limited jurisdiction that are empowered to exist at the level of the city or the town, with subject matter jurisdiction ranging from traffic citations to local ordinances, to small civil claims, to sometimes criminal misdemeanor charges. These courts go by a variety of names. I've seen 15 to 20 different names for these courts, including municipal, town, summary, justice, mayor, and police courts. But municipal court is the most commonly used, and for simplicity in this discussion, we will primarily refer to them as municipal courts. Some of these courts are quite large and well organized, like the City of Seattle Municipal Court, which alone filed more than 10,000 misdemeanor cases in 2019, while others are very small, like a police court in Louisiana that I recently heard operated for a time out of the living room of a city official. In the aggregate, these small courts make up a substantial total of the judicial operations in the United States. There are over 7,500 such courts in 30 states scattered around the country. They adjudicate over 3.5 million criminal cases every year, and they collect over $2 billion for local jurisdictions in revenue. So under what authority do these courts even exist? Well, the Supreme Court said in Missouri v. Lewis that it is the right of every state to establish such courts as it sees fit, and to prescribe their several jurisdictions as to territorial extent, subject matter and amount, and the finality and effect of their decisions. Thus, in every one of the states where municipal courts exist, a constitutional provision and/or statute either allows for or mandates the creation of municipal courts. This is normally located in the home rule authority of cities. In most states, the jurisdiction of municipal courts is limited to the enforcement of municipal codes. But in some places, municipal courts are also granted the power to hear cases involving state misdemeanors committed within their physical boundaries. State laws can be very specific about the territorial jurisdiction, subject matter jurisdiction, penalties, and several other aspects governing the formation and administration of municipal courts. So where do they exist? Municipal courts exist in 30 states around the country. In 27 states, municipal courts have criminal jurisdiction over locally defined crimes and can impose convictions and criminal punishments for those crimes. What kind of cases do they hear? Municipal courts are the places where cities and towns can enforce their own codes and ordinances. In 27 states, municipal courts have criminal jurisdiction over locally defined crimes and can impose convictions and criminal punishments for those crimes. Depending on the city, these local crimes codes and ordinances can be substantial, ranging from traffic citations to pickpocketing, disturbing the peace, disorderly conduct, public nuisance, littering, prostitution, gambling, vandalism, trespass, firearms offenses, sleeping in public, aggressive panhandling, drinking, drug possession, and much more. According to Professor Nadapov, municipal courts generate over 1/4 of the 13 million criminal misdemeanor cases filed annually nationwide. In other words, at a bare minimum, municipal courts generate more than 3 million misdemeanor cases every year. To extrapolate the human impact, assuming that each case in the municipal court misdemeanor cases only involve one person, that means that nearly 1 out of every 100 Americans is involved in a misdemeanor case every year. How are they different from state courts? State trial courts, also some of limited jurisdiction. Municipal courts have been called courts of convenience that exist to provide speedy and inexpensive means of disposition of charges of minor offenses. They can be extremely informal, with little to no evidentiary record. They can separate from and are often unaccountable to the unified state judicial system. They often lack grand juries or jury trials. They are often adjudicated by non-lawyers. Rulings sometimes imposed by judges are sometimes imposed by judges who hold multiple positions, like in the mayor's courts. They are often not subject to some separation of powers constraints. Defendants are sometimes not guaranteed a lawyer in proceedings in some states. And 14 states permit police officers to file and prosecute cases directly in lower courts without any attorney prosecutor present. In most states, decisions can be appealed to a state trial court of general jurisdiction with de novo review. How are these courts funded? While most municipal courts are supported by a combination of state and municipal revenues, one of the major issues that has arisen with municipal courts is the extent to which they are supported by fines and fees that are imposed in the courtroom. As the 2015 U.S. Department of Justice investigation of Ferguson showed, the city of Ferguson showed, the revenue from municipal courts can supply a substantial percentage of municipalities' budget and thus incentivize systemic overcriminalization. Most municipal courts get less than 2% of their revenues through fines and fees, but some have been seen to be as high as 15% or more. How are the judges chosen? In roughly half of the states with municipal courts, judges are picked in elections, and in roughly the other half, they're appointed. The appointing body can be different in each municipality. These methods for picking judges can vary in different municipalities, even within the same county. I once helped a judge on her nonpartisan reelection campaign for a municipal court in King County, Washington, and just 3 weeks later, helped a different candidate for a different municipal court judgeship for the next town over work on his appointment to a municipal court position that was hired by the city manager. In another town in the exact same county, municipal court judges are appointed by the mayor. So what's the role overall that these courts play in our local democracy? And I think this is the crux of what we're trying to get to in this presentation. As we discussed in our last panel, municipal courts can create many social and cultural issues in our local communities. In short, these courts often lack the independence, impartiality, and due process that we consider the hallmarks of a developed judicial system. As we discussed above, municipal courts are often the only judicial system that millions of Americans are engaging with every year. Whether people have a positive or negative impact in those courts makes a significant impact on the public impressions of the judiciary writ large. This can be especially problematic when one starts to consider the many challenges associated with these courts around the country. They're sometimes criticized for their rushed and dehumanizing mannerisms, their lack of due process, their tendency to criminalize poverty and race, and their over-reliance on fines and fees. This is obviously not the case everywhere. We have some fantastic judges here on this panel who have been working to make their municipal courts very different from that, but it can be a problem in many jurisdictions around the country. These courts also sometimes pose direct contradictions to the separation of powers especially in instances where city executives like mayors serve as both the mayor and also sometimes the municipal court judge. So with that framing and introduction, I'm now very excited to turn this panel over to the Honorable Judge Andrew Sparks of the Birmingham Municipal Court, who can provide more details from his rich experience working in and through his court to deliver justice for his community.
Good morning. Good morning. So glad to be with you again. My name is Andre Sparks, and I am the presiding judge, have the honor of serving as the presiding judge for the city of Birmingham. And I'm glad to be with this panel once again to talk about some of the, I think, very, very real issues associated with municipal courts. The overview you just heard gave a general overview of how some courts operate within our country. And I think that perhaps is part of the core problem. We don't really have any major institutions that talk holistically about standards for municipal court. So a group of judges from around the country have been trying desperately to create a national organization for municipal court judges so that we can frame the conversation in ways that are beneficial and establish those best practices. Some of those judges you'll hear in the upcoming webinars that we'll have. I want to talk about how we deal with municipal courts here in Alabama. It's best for me to talk from a perspective that I know of, having been in the practice of law here in the state since the late 80s. I believe I can give you a pretty good perspective. All the names that that were previously used to talk about municipal court are correct. Most of the time we hear city court. That's the biggest one we hear, or traffic court. Those are the terms we hear. But at any rate, when we hear those terms, the perspective of the person talking is usually a court that's not as important as other courts. And so I've come today to talk about how I believe municipal court perhaps is certainly no less important, and perhaps maybe even more important than some of the other courts that individuals attend. As you heard, most individuals will at some point in their lives have to deal with a case in a city court or a municipal court. In those cases in Alabama, where a municipality does not have a municipal court, those same cases are heard at the district court level at the county. But in those areas of the state of Alabama where we have municipal courts, and I should tell you by way of reference, let me just give you some numbers. By way of reference, in Alabama, there are 286 municipal courts in the state of Alabama. 286 municipal courts. There are only 67 district courts. There are only 41 circuit courts. There are 106 district court judges, and there are 148 circuit court judges. So the number of municipal court judges is greater than the combined number of district and circuit court judges within the state of Alabama. And I would suggest to you that any group of individuals who have the kind of sway we have over individuals' lives is probably due to be listened to and reckoned with and trained. I should also tell you that the municipal courts in the state of Alabama are a part of the unified judicial system. We follow the same rules and regulations that are followed within the state courts. When we are brought to the bench by different methodologies, but by and large, the judges in the state of Alabama that serve in municipal court, either part-time or full-time, are appointed by the municipal legislative group or the city councils within the state of Alabama. If there is more than one judge within that municipality, then the mayor has the executive authority by state law to select one of those judges to serve as the presiding judge or the lead judge for that municipality. There's a commonality that exists among these judges. And I can tell you this. First of all, there's an assumption that all of these courts are large, are small. Not so. Most of the larger courts that are municipal in the state of Alabama are larger than some of the district courts that are in the state. Our caseloads are heavier than those district courts. In fact, the city of Birmingham, which is perhaps has one of the larger caseloads annually here, is between 7,000 and 10,000 municipal misdemeanor cases. In addition to the tens of thousands of traffic cases that we hear. Those misdemeanor cases range from the violations that were mentioned earlier, but they also include domestic violence cases. They also include drug cases. They also include all manner of substance use disorder cases. And so it's for that very reason that the judges who serve within municipal courts have to be as versed in the law and trained in various subject matters as any other courts. Use a little alliteration to help you understand this. The judges who serve in the largest courts, and I can tell you, of the 286 courts in municipalities in Alabama, fewer than 10 full-time courts. And by that, I mean fewer than 10 have full-time staffs. The rest are staffed by part-time judges that meet a few times a month and that have staffs that run the courts in between. But of the larger courts, we are staffed every day. We have dockets morning and afternoon each day. The city of Birmingham has municipal court has over 100 employees. We have 9 judges that have been appointed to hear our dockets. By any stretch of the imagination, we are a busy court. And we, to use that alliteration, there are 3 things that we all have in common. We are competent, all lawyers from some of the best schools throughout the country. We all understand evidence-based practices, follow them within our activities. We're all trained in various specialties. The city of Birmingham Municipal Court has every specialized court one can imagine, drug court, a DWI court, veterans treatment court, a homeless court, a bilingual court, domestic violence court. We have every specialized court, and the judges are trained in those areas so that we can ensure that the citizens receive the best possible services we can give them. So we're all competent. Not only are we competent, we're collaborative. We understand, as most courts do in vibrant cities, in progressive cities, that there are certain things that are not within the purview of a court to do. And so we can't be effective in the execution of our duties if we don't collaborate with partner agencies outside of the court. You can't run an effective a domestic violence court if you don't have a supportive victims support group from the community. And so it's important that we collaborate with them. It's hard for us to run an effective drug court or substance use disorder court without having nonprofits in the community who will help us with treatment and support people who are struggling. And so, by way of example, the city of Birmingham has been continuously funded almost since 2008 by a drug court grant. We've received over $7 million in drug court grants to support people with substance use disorders. But our chief collaborative partner is one of the largest drug treatment providers in the state of Alabama, Alethea House. And so we have to be collaborative. Those judges who manage these courts have to understand the nature of collaboration and be able to foster those types of collaborations. So not only do we have to be competent and collaborative, we also have to be creative, finding new ways to understand how we can help people who have the same problems. I'm yet to have anyone tell me the difference between a misdemeanor drug addiction and a felony drug addiction. And so we make sure we support people when we see them. In fact, my notion about supporting people is we won't be the latest governmental agency to let you down when you come to us and you have issues. And so we make sure that we reach out. We have 8 social workers on staff at this court. Not all municipal courts are created equal, and it has to be those who are progressive. So creativity is part of our lifeblood. We have to determine why so many people in the state of Alabama are driving without driver's licenses. What can we do to help them get their driver's licenses? And so the creativity sparked a program called the Renew program. Guess what? We case manage driver's license issues like you case manage any other problem, social problem that people have. We have a staff dedicated to helping people get their driver's licenses back to them. And to date, several thousand people have been able to either get their license for the first time or renew their license. That's the name of the program, Renew. But of course, we run into the same social issues that every other agency runs into. The reason so many people don't have driver's licenses in the state of Alabama is because of literacy. That's not an issue that is endemic to the court. That is a social issue that we need to work out. And we're simply victimized like everyone else by that. We also realize that in the city of Birmingham, we have a high percentage of people who live below the poverty level. Because of that, we do hundreds of hours of community service to support them. But not just community service that you think of in terms of punishment. We do life skills community service that enriches their lives and makes them better. And we give them credit for going back to school to try to get their GED or getting their high school diploma. Creativity is the blood of growing courts. Judges in my sphere have to be appointed by the legislative group. So any judge who sits at a municipal court in the state of Alabama must understand the politics associated with getting the seat in the first place. You got to convince the council, the legislative branch, to appoint you. Full-time judges serve for 4 years. Part-time judges serve for 2 years. Once selected, maintaining that position is not just sitting on the bench all day, but it's also being a part of the community that we live in. It means supporting activities within the community. The same requirements that any other judge has, we have those same requirements. We walk a tightrope, particularly those of us who serve as presiding judges, because not only are we working with the legislative branch for appointment, we also have to maintain and support issues coming from the executive branch or the mayor's office. As a department head, I am in a place of actually running a department, but I have a separate branch of government that I'm responsible for. And all the constitutional requirements that are necessary to be protected, we still have those responsibilities. Municipal courts are necessary to our community because it's the lowest level of judicial exposure that most people will come into. I believe if we do our job properly, they don't ever need to leave us and get another charge at a different level if we can catch all of the issues they are dealing with. I know there's much more to be talked about, and I'm excited to see what my colleague, Judge Howson, is going to say. And so I'm going to stop talking and turn it over to her at this point. Hello, Judge Howson.
Thank you so much, Judge Sparks. What kindred spirits we are from all the way across the country. I am Judge Howson. I am in Northwest Washington State, across the country from Alabama there. I am the presiding judge of Skagit County District and Municipal Courts, and that's a coalition, which is a unique design. It's one district court and 3 municipal courts. And the structure of those courts are that judges are assigned to a municipal court and preside over that municipal court in that particular city 1 day a week for full day calendars. And then they also do jury trials 3 days of a month each month. And we have judges that are assigned to each court. I assigned myself to the Mount Vernon Municipal Court. I have a deep love for municipal courts, having practiced as an attorney for over 30 years in these very courts before I became appointed as a judge and then as I became elected. So I am an elected judge. I preside over all 4 of those courts, making sure that the business aspect of the courts is functioning smoothly and properly, handling the budgets for each of those courts. And I also do all of my regular judicial duties, presiding over the full calendars. We call these municipal courts often referred to in our area as the People's Court. And that's because, as Judge Sparks said, and everyone else has alluded to, This is the court where most people will have some contact with our municipal courts at some point, and not everyone does with the other courts. And so we work very hard all across our jurisdictions to make sure that we have access to justice that meets the needs of the people. All kinds of people have interactions with the municipal courts, from witnesses to jurors, to traffic citations, all the way up to the criminal charges. And as Judge Sparks says, we handle the drug charges and the domestic violence charges. We handle all kinds of crimes of poverty and crimes of homelessness, and the volume of our courts is extremely large. So we'll handle dockets with up to 150 cases every single day. And our job is to make sure that we're treating each person with the respect and dignity that they deserve, so that they feel heard and the underlying issues are being resolved. So when I first came on the bench back in 2017, everything about all of our municipal courts was handled in a adversarial system. The traditional prosecutor, defense attorney, court making the decision. And what I saw within 3 weeks of being on the bench was the revolving door between the jail and the citizens over these misdemeanors, and how much more time they were spending in jail than was necessary for the crimes that they'd been alleged to have committed, or they were awaiting trial. And so within about 3 weeks, I began a program very similar to Judge Sparks describing, and we called it the relicensing clinic. And it is an off-record court hearing that we hold, and we do it twice a month, and anybody in the entire county can appear, and I walk the person through the steps to get relicensed. And we have volunteer lawyers to help with bigger issues for the person. And we also walk them, just really help them with all documents for getting fees waived and fines waived and court costs recalled from collections and freeing up holds on their license. And that program has been going then since 2017, and thousands of people have been licensed and insured. And it's become a model for across the state of Washington, and we're really, really proud of that. Shortly thereafter, I also saw that revolving door for the crimes of poverty and homelessness, and that were affecting the businesses in our communities, and began working on, in 2020, a very complex network of therapeutic treatment courts, so that every single person in our county and all of the municipal courts could have the same services available to them. So we created a network for treatment courts that has been hugely successful. We have over 450 current participants and close to 1,000 graduates since 2020. So we're really, really proud of that program. And in order to do that, we had to do collaboration and negotiation with the local government. So if you can imagine 3 municipal courts and a district court, but 3 municipal courts, each has a mayor, each has a city council. And I had to go out, and it became very important to me to get to know each of those mayors and each of those city councils, including the individual participants on the city council, get to know them, to appear at their meetings, to understand the issues across the cities that they were dealing with. And historically, the judges had kept the separation of powers to a more extreme level. And so what I did, I just wanted to understand what they were faced with and what was important to them. And so oftentimes my city clerks, our court clerks are usually typically longtime residents of each individual city, and they typically work at the court beginning from age of 18 all the way up until retirement age, and they become an integral part of each community. And that's important to our court system, that connection is made. So the court clerks and myself, we go to those city council meetings, and we speak when an issue about the courts is before those bodies. And that's not just because we might be called upon, but it's just to show that we are listening and we're collaborating. And so always it's a tight tension with the separation of powers. So we have rules governing that, and we pay attention to those in almost every meeting we ever have with mayors or with city councils. We will bring up that. I can't answer that question as the judge. You can't, or we'll say, you can't tell the court that. You can't ask us to tell you this. we'll always be raising those separation of powers issues, but we'll do it with an open mind and a fresh look. I heard Judge Sparks talking about collaboration a lot, and that is key. It is exactly what we try to do, is collaborate. We do a lot of listening, and we try to address the issues that are facing the community. We act as if we are the community members that we are, and we try to have the public confidence in our communities, in the courts, be raised to a newer level. And I think we've been effective at doing that, but it's an ongoing effort, and it takes a lot of additional effort. So almost every week, I'm going to at least one evening meeting. Every lunch hour, maybe 3 times a week, I'll attend different meetings with different community groups, and I'll just listen to what is important to them. So for example, local businesses, their issues with homelessness and crime in their stores. Some of them are really, really upset. And so I talk with them about the community court model that we developed and how they could become part of our advisory board. And we just listen, collaborate, and try to have them understand that the court is a part of the community and that they have a voice, and to hear our perspective and what we can and can't do. So as far as funding goes, I am responsible for presenting the budgets for each of those municipal courts to each of the mayors and the city councils. And part of that process, I believe we've also stepped up a bit since I became presiding judge. And then by that I mean that I have pre-meetings. I set up an individual meeting with each mayor and talk about what's of interest to the court, what they can expect to be coming from us. And I also meet with city council members and talk about, I attend coffee meetings that are public meetings and the public can join, but I'm there to answer questions from the public, or I'm there to present what budget issues might be coming up. And then I do attend the meetings when those budgets are being passed and present the budgets. So when we were developing these therapeutic courts to be responsive to the needs of the community, we put together as much of the budget request as we could from the individual cities. But then when that was not going to be sufficient, we started small. So that we started small with a little program and said, let's show you what we can do with this model. And then we expanded to the huge, it's almost larger now, our therapeutic court. In fact, in one city, it is much larger than the regular traditional court. So we went to models like direct citing. That's involving collaboration with the law enforcement. So they direct cite to our therapeutic court program. And so some of these, when trying to determine the budgets, we would go put a hodgepodge together of state funding, federal funding, local grants, any grants I could find, and then show data and take that data to those governing bodies and to also the financial administrators is another piece, to have them educated and understand about what a difference therapeutic court can make, and that they understand that it's not the easy road out. It's actually much more accountability to participate in a treatment court than it is in traditional adversarial court, and that how that can ultimately reduce the costs of incarceration and the costs of recidivism on their cities. And so we've been effective, but it does take a whole lot of effort to go to each city and each governing body, and then not only do it one year, but do it the next year and the next year and the next year. We also do build relationships in the community, as Judge Sparks was mentioning. It's another thing we do here in the Northwest. We speak regularly at Rotary clubs, Kiwanis clubs, service clubs, present the data, the numbers. We meet with legislators. We meet with any of those local government entities in order so they can understand what we do, what we can't do, how that separation of powers works. And then we just listen and we field questions and try to be responsive to their needs. And as I mentioned, invite them to be part of advisory boards for therapeutic courts and things like that. So that's in a nutshell what I do in terms of creating new programming that can affect the cities and the municipalities. And I think that's all I have. So I'll turn it over to Professor Weinstein-Hull.
Okay, wonderful. Thank you so much. That's really inspiring to hear. I really appreciate all of those sort of specific examples about the ways that Judge Housen and Judge Sparks, you work with your community and community organizations and local governments to do these extraordinary things. Um, I want to provide the sort of final segment of this webinar, taking things even, zooming out even one more level, and talking a little bit about the relationship between municipal courts and their states, and sort of the broader justice system. Municipal courts are a huge part of the justice system in the sense that they resolve so many of the cases that are brought each year, but there are other pieces of the justice system as well, namely the state and federal systems. As others have mentioned, municipal courts are courts of limited jurisdiction, which means that they hear cases up to a sort of certain level of sort of seriousness or stakes. So in the civil context, they'll hear cases up to a certain amount of money in dispute. Sometimes in Arizona, where I live, it's $10,000, but in some states it's slightly more or less. In the criminal context, they'll hear misdemeanor cases or cases that don't go beyond sort of a certain amount of time, potential time in jail. And beyond that, state courts or courts of general jurisdiction hear those sort of broader or larger claims. And so municipal courts are part of the system of state law as part of the state organizational chart. And in fact, appeals from municipal courts generally go to state general jurisdiction trial level courts, which either serve as appellate courts or conduct de novo trials, depending on the state and the form of sort of record keeping that exists at the municipal level. But despite being a part of the state system, municipal courts are often quite independent from the rest of the state. And again, this depends on the state, and so I'm sort of speaking in generalities here, but research that I've done, especially in an article called The Structures of Local Courts, has showed that municipal courts often receive limited sort of administrative and substantive oversight or relationship with their state court systems. So some municipal court systems, for example, receive some funding from their states, but many do not. Many are funded solely by their municipalities or by fees and fines generated in the courts themselves, or don't receive budgetary oversight of any kind. When it comes to municipal court facilities, like their buildings and whether or not they're accessible, many state systems provide no management responsibilities over municipal court facilities. Many states provide no or limited, sorry, I just want to make sure I'm still on. Oh, am I still good? Okay, I'm still good. Great. No or limited legal counsel or legal advice to their municipal courts. And in addition to that, independence from state administrative systems. There also isn't always much sort of substantive or legal back and forth between municipal courts and their state court systems. So I mentioned that most appeals from municipal courts go not to state court of appeals, but to state trial level courts. And although the appeals rate is actually sort of hard to get a handle on from municipal courts, and certainly varies by state and by court, in general, what we know is that it's quite low. Lower than the appeals rate in the federal court system, at the very least. And so the vast majority of cases filed in municipal courts both begin and end at the municipal level. And beyond sort of even the state system, federal courts hear federal claims, or they might hear some state claims that exist between parties of different states. And although we sort of hear about federal courts and the Supreme Court in the news all the time, there are many fewer federal cases per year than state cases, and many fewer federal cases than municipal cases. In theory, you can do what's called remove a state court case to the federal courts under certain conditions. So there can be a direct relationship between state and federal courts, but in practice, there are a set of federal courts doctrines that actually sort of shelter state and local courts from federal interference. And I don't want to go too deep into the doctrinal weeds here, but there are federal court doctrines called preclusion, abstention, habeas corpus that each require federal courts to defer to state courts in certain circumstances. And in practice, because of the low appeals rates from local court to state courts, those federal doctrines actually can end up sheltering and protecting local and municipal courts, which is a mixed thing, I think. So on the one hand, it's good for the federal courts to respect the work that happens in state and municipal courts, in part because of that close relationship that municipal courts have with their communities that Judge Howson and Judge Sparks have been speaking about. On the other hand, sometimes we might want a little bit more federal oversight of these courts. I mean, like every institution, things can go right and things can go wrong in municipal courts. That's true of all courts. And because of those federal doctrines, the federal courts don't play much of a role in providing oversight. So, in many ways, although municipal courts are a part of the state system and play a role in the federal system as well, they're actually also fairly separated from those two systems. Okay, that was just a very sort of brief overview of relationships between the municipal courts and the state and federal systems. And that actually concludes the kind of instructional instructional portion of the webinar. And from here on, I will look to see whether there are any questions in the question box, or I might sort of pose some questions myself to the panelists. It would be great if we could all be sort of spotlighted at this point. So the first question I want to ask is, I was speaking to a judge the other day, and she mentioned that she felt that the sort of role of the municipal court judge had changed in the last 30 years or so. That the kind of sense of the municipal court judge as a figure that can really help the community and become integrated into the community is one that is maybe a little bit more recent, that in the 80s or 90s wasn't something that municipal courts had in mind. And I was wondering if I could ask the judges here whether you also detect that kind of change. Is this idea that Judge Howson and Judge Sparks you're speaking about of sort of judges as helpers, community helpers, is it a recent idea, do you think?
I think Judge Howson said it really, really well. I think what's happened is we're in a stage of evolution in the criminal justice system anyway. And I think that's finally making its way down to local courts, as we've been talking about them. Judge Howson mentioned the phrase non-adversarial courts. And what is really happening is the advent of accountability courts or drug courts, which started in the late 80s, has infused the criminal justice system. And we found that we are able to accomplish more and better when we are less adversarial. And I think that's making its way into the criminal justice system. In fact, the procedural protections that come, procedural fairness issues that we deal with in those accountability courts is perfect for what we do in local courts like municipal courts. And so I think that's what we're seeing, Professor.
I would just agree with all of that and also say that it's not 100%. It's not even close. I have a lot of division even within my own bench, within several of the communities. They're at different levels of comprehension or understanding of what treatment courts can do, or what fines and fees, why the fines and fees issue is affecting participants, why the shift. We no longer want to present our budget saying this is how much money we're bringing in, and so therefore this is why we're asking for all these things. We have to ask for the things we need and want, regardless of how much money we're bringing in on fines and fees, because the laws are changing so dramatically. But what I do notice is all the way down from the court clerks all the way up to the other judges I work with and everybody in between, Not everybody is completely on board with all of these changes, and I have to try to lead, knowing that it's the right thing to do, and that I have the administrative office of the courts behind me and all of you fine, brilliant minds. But it's not there all the way, for sure.
I
And
agree. I agree
there's a lot
100%.
to learn and a lot of education, and uh, we just have to keep trying.
Uh, Professor, one thing I don't think is ever talked about in these hearings is the courage it takes for some of these judges who lead these municipal courts to to go against the grain of normalcy, to talk to and advocate before these municipal leaders, the mayor and the council, to educate them about the benefits of doing things the way we kind of do it in this new form. It takes courage because you expose yourself professionally, and the blowback can be swift sometimes when people don't agree with you. But when it works, and it doesn't work all at once, as Judge Housing says, when it works, it takes years in order to put a system in place that is consistently beneficial. In Alabama, the state doesn't give municipal courts anything. But you saw how many courts we have, and they take fines, fees, court costs. They take all those things, but they don't send anything back. At some point, that imbalance is going to have to be redressed. Because the cities, as in anything, are taking on the entire load of the justice system within their jurisdictional boundaries. And none of that state money comes back.
You know, I'd love to follow up about that. I think, we have sort of two inspiring examples, here on this panel, who are doing all of these wonderful things. But you mentioned that it sort of requires going against the grain. It requires courage. I mean, how can we make it sort of more commonplace that municipal court judges are open to doing the kind of innovation that you two are open to doing? I mean, might it be might we incorporate it into part of judge training programs at the state level, or a sort of, might we be able to create networks of municipal judges? I mean, I'd love to hear your thoughts about how we sort of get from here to there, in the sense that we make, sort of your approach the more common approach among municipal judges.
I do think, and it also addresses one of your earlier points, that in Washington here, Washington courts, we do have associations that are combined district and municipal courts, and we do have a lot of training, and we do present seminars on these therapeutic courts. And I happen to be the co-chair of the therapeutic court committee for all of the municipal courts and the state court, district courts. And we do share information, and everyone is working hard to do that. But that doesn't mean all of the judges in all of the jurisdictions are actively buying in. So I just continually say, let's try to get this onto one of our conferences. Let's bring pretrial reform for municipal courts into these conferences. But there is some resistance, and it's mostly education, I'd like to hope, and not all mindset.
I agree. And I've noticed that there are pockets of the country that are further along in this discussion than others. On the Northwest, I know Colorado has been doing some great things. I can name states that have made great strides because I know the judges within those states. You'll have one, Judge Linda Cook, on one of the seminars after this. She can certainly tell you, which is why I mentioned earlier that several of us judges have been trying to get together to create a national group that can help frame discussions and identify for some of these executive and legislative leaders what best practices they should be looking for when they're hiring judges and appointing judges. We need to give some framework for that, understanding how different it is across the country. We have to have something that's general enough for them to stick a pin in, but it's going to take us sitting down and creating that. We've worked with the National League of Cities to try to create an entity like that. More of that kind of work has to be done.
That's great. So we're getting short on time, I'll mention just two things. One is that some folks from the audience were hoping to get contact information for our panelists. If you're comfortable with it, if you wouldn't mind putting that in the webinar chat, I know that a bunch of folks would appreciate it. Another question from the chat that I want to pose, and the question is, when you start these diversion programs or go against the grain, how have you gotten others on board that have been apprehensive? Do you have any examples of how you were able to persuade them or the creative ways that you were able to do so? And I think this will probably be our final question, unfortunately.
I'll just start in and say start small, start with an idea that I can build consensus with and grow from there, then relying on the data. I also don't personally like to spend a lot of time in meetings with, especially if they're with a bunch of people who don't agree with what I'm trying to do at the outset. Like, I don't try to sit down in that first meeting and have, like, let's all agree. I'm always trying to keep all the balls in the air with, like, public defense, prosecutors, community members, or the local governments. And so what I try to do is find some small area of consensus and build from that, and then show data and continue.
Yeah, I think there's a saying that all politics is local, and it is. And that means getting, as Judge Houston said so wonderful, getting to know people, sitting down, letting people sense the sincerity of the approach you're trying to take, and then giving them examples. I personally, people always want to start out getting grants to do things. I don't believe in that approach. I believe in taking the resources that we have, creating a model with what we have, and then going to funders and asking them to expand what we're doing in our pilot, because then we have something to show them, which means you're going to have to be creative in how you start out at the beginning. But at the end of the day, it's about educating and teaching people that there's a different way that we can do this and help people. And I believe all right-thinking people are receptive to those conversations.
That's wonderful. Thank you. We have reached the end of our webinar. I want to thank the three of you so much for sharing your experiences and your knowledge. And I apologize to everyone in the who is attending if we didn't get to your question. If you have follow-up for any of us, please do feel free. I think we'll end the webinar here. Thank you so much for being here.